What is perhaps the most common reason for the U.S. Trademark Office to reject trademark applications from new clothing brands? Hello and welcome. This is U.S. Trademark Attorney Eric Kelly. In this video, I will show you how to avoid a very common mistake that new clothing brands make with respect to their placement of their trademarks on their various articles of clothing. Okay, let's get into this. Okay, first I need to kind of give the backstory or explain how this kind of problem arises. And to do that, we'll look at some clothing brands that have had some problems with their trademark registrations at the U.S. Trademark Office. So to begin, we're going to go over to the USPTO.gov website. Right here, we'll do initial trademark search. So I'll come up to trademarks, and we'll go to searching trademarks, search our trademark database. We'll do the basic search. And I'm going to enter a serial number of a trademark that I've already looked up. Submit query. So this was a clothing brand called Butter. As you can see their status. This registration application was abandoned, and they filed in class 25, which is the basic class for clothing. You can see that their products were t-shirts, graphic t-shirts, short sleeved or long sleeve t-shirts. Okay. So to explain the problem, I will click over here on this button, TSDR. And this will show us what was filed in this particular trademark application. So we'll click on documents to look at what was filed. And at some point in a trademark application, you have to provide what's called a specimen. And the point of the specimen is to show how the trademark is being used out in the real world. So for clothing, for articles of clothing, you generally want to show how the trademark is being marked on the clothing. So let's go ahead and look at their specimen. Okay, and this is a very common usage where the clothing brand will basically put their brand very prominently in the front of the t-shirt or whatever the garment may be. It could be a hoodie or a sweatshirt, whatever. But the problem is the Trademark Office doesn't consider that trademark use. They consider this to be ornamental use or decorative use. So let's go back to the documents, and you'll see that they received what's called an office action, a non-final office action. So we'll click on that. So this is for the trademark Butter again, a non-final office action. And this will tell you that the problems that were raised. So they had two problems. One was a likelihood of confusion problem, which we're not going to talk about. But the point of this video is the problem with their specimen. And they said, and this is the second issue right here, where it says the mark is basically only being used in an ornamental fashion. So if we go back and look at the specimen, that's what they're saying. They're saying you can place your trademark in this region on the garment. That's fine from a business or marketing perspective, but it's not fine from a trademark perspective. So if you do this, which is fine from other perspectives, you would also need to place the trademark somewhere else on the garment to qualify as trademark use. And that typically would be somewhere in this region here, where the trademark should appear on a tag or a label on the garment. Then that would be appropriate trademark use. Now here what they did is they put a B, which is not the trademark they filed for is Butter though. So what we should have seen on this little tag is the trademark Butter written out. If that had happened, then they would not have received that particular office action with a rejection focused on the trademark being merely ornamental. Okay, so let's look at another example. Look at a completely different example. Again, I'm just putting in a new serial number that I've already looked up. So here is a clothing brand called Credible Wear. Again, they were filed in class 25 for all those various different types of clothing. So again, we're going to click on the TSDR button, go to the documents. We will look at their specimen. Similar problem as what we saw in the first example. Their trademark that they applied for is Credible Wear, but it's being used in this example only in an ornamental or decorative fashion. We don't see a tag or a label attached to the garment with Credible Wear on that tag or label, and that's the problem. So we go back and look at their office action. you'll see again, the first issue raised here is that failure to function as a trademark merely ornamental, which is essentially the same problem we saw in the first example. Okay. So again, looking at the specimen, again, you can put your trademark prominently on the article of clothing. That's fine, and that's desirable from a business or marketing perspective. However, doing that by itself is not sufficient for trademark marking purposes. In addition to this usage, which is the decorative or ornamental usage, you also really want to attach a tag or a label. It could be a hang tag or a sticker to the garment, and then whatever the trademark is that was applied for should appear on that tag, label, or sticker or hang tag. Okay. Okay, let's look at another example. So again, just entering a new serial number that I've already looked up. Again, so this is Seahawk Racing Team was the clothing brand. Again, it was in class 25 for a bunch of clothing, different types of clothing. We'll click on the TSDR button. We'll look at the problems that they ran into. Go over to documents. So let's click on the office action first. Again, you see some of the, over here in this summary of problems that they had a refusal based upon the ornamental use of the mark on the clothing. Okay, so let's look at their specimen. Or hold on, going back to the office action, there's also two other issues that were raised, but we're not going to look at those. We're just, again, for this video, we're focusing on the problem that shows up in some of these specimens for clothing where the applicant is only using the trademark in an ornamental or decorative fashion prominently on the article of clothing, and they're not attaching a tag or label to the article of clothing that has the trademark on the tag or label. So let's look at their specimen and see what they submitted. Okay, so this one, they did a hat and a t-shirt or some kind of shirt. And again, on the hat, you don't even see the applied for mark. The applied for mark, what was the applied for mark? Seahawk Racing Team. This is the applied for mark, Seahawk Racing Team. So that's what needs to appear appropriately on the given article of clothing, okay? So looking back at their hat, you don't see that particular mark anywhere. And then I'm looking at the shirt in the prominent graphic region. Again, this is just ornamental or decorative use. It doesn't count as trademark use. Now, what's interesting about this shirt is they do have a hang tag here. However, what's shown on the hang tag, it actually says Seahawk Offshore Racing Team, which is not what they applied for. They applied for Seahawk Racing Team, so that's the problem. This label doesn't say Seahawk Racing Team. It has the additional word of offshore, so that was their mistake here. They almost got this right, but the mark that's showing on this hang tag is not the mark they applied for. Okay, let's look at one final example. Again, just entering a serial number for a trademark that I've already looked up. Submit. So this was basically a stylized logo, which is a stylized version of the letters C and F. And again, it's abandoned because they ran into problems with their specimen. They were in class 25 for various clothing. We'll click on the TSDR button and go to the documents to see what happened. Go to documents. Let's look at their non-final office action. Again, there's a bunch of issues raised, but the one we're focusing on for this video is the ornamental refusal. Okay, so let's look at their specimen. So again, look at this beanie here. All they're doing is placing their logo, which is what they applied for, prominently on the beanie. And this is, again, counting as decorative or ornamental use. What they should have shown in this particular specimen is a hang tag or label attached to the beanie that had this particular logo on the hang tag or label. Okay, so as an example, let's just look at a blank kind of generic t-shirt. And as we've seen in these examples, you can place your trademark or whatever graphic designs you want in this particular region of the garment. However, and that may be desirable from a business and or marketing perspective. So you're perfectly allowed to do that. However, if you do that, you have to, in addition, attach the trademark in some other fashion to the garment that qualifies as trademark use. And typically on a t-shirt or a lot of at least upper body garments, you'd find a tag or a label in this particular region, and on that tag or label, the trademark should appear on that tag or label. Okay, so it could be a hang tag, it could be a sticker, that's fine. And the tag could appear off the sleeve or off the bottom too, that's fine. But again, if you're going to use whatever you put here on the front, in the prominent area that takes up a lot of space in terms of graphic design, that particular use does not qualify as trademark use. So that's really what we're trying to hit home here. So if you do that, again, that's fine on the one hand, but if you do that, in addition, you want to include a label or a hang tag or a sticker somewhere on the garment, and your trademark, the trademark that you applied for, exactly as you applied for, must appear on that tag, label, or sticker. Additionally, another option would be to place the exact trademark that you applied for on the exterior packaging. So let's say this particular t-shirt gets packaged in like some kind of clear cellophane type plastic bag. On an exterior of that plastic bag packaging, the trademark could also be on a sticker or a label or printed, and that would work as well. Okay, so if you can avoid this most common mistake for new clothing brands with respect to how they place their trademarks on their clothing, you can avoid the most common reason that the Trademark Office rejects trademark applications for new clothing brands. So hopefully this helps you. And in addition, because this is such a common problem at the Trademark Office at the USPTO, the USPTO also has their own particular video on this particular subject, so you can also check that out. So here's a video from the USPTO that also touches on this particular issue that we've been talking about in this video. So here's the web address, the URL for this particular video. Okay, and this is, out of all these videos here, this is part 8 of their series, which focuses on the specimens. So you can take a look at this as well. That'll also explain this particular issue that we've been discussing here. Also, this particular Google search was able to pull up that video at the USPTO that talked about this particular problem with specimens on clothing. So you could try that as well if you want to find this video and watch it. Okay, to wrap up this video, I'm U.S. Trademark Attorney Eric Kelly, and I do work with clients from all over the world and all over the United States. As an intellectual property attorney, I do handle trademark matters, patent matters, and copyright matters. The subject matter for this particular video was dealing with trademarks, and trademarks are an intellectual property tool that is there to protect your branding. Patents are another intellectual property tool which are there to protect new products, essentially. And copyrights is another intellectual property tool which is used to protect creative content, things like music, videos, photographs, and things of that nature. And lastly, you can see some contact information for me if you want to reach out to me regarding intellectual property matters. Thank you. Please like this video and subscribe to help me reach others about intellectual property matters. And here's some suggested videos on U.S. trademark issues.